Friends, good morning. I am again before you with new section, that is section 311 of the CRPC 1973. What this section 311 says, it deals about power to summon material witness or examine person present. Any court may at any stage of any inquiry, trial, or other proceeding under this code summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re examine any person already examined, and the court shall summon and examine or recall and re examine any such person if his evidence appears to it to be essential for the just decision of the case. Fair trial is the main object of criminal procedure, and it is the duty of the court to ensure that such fairness is not hampered or threatened in any manner. Fair trial entails the interest of the accused, the victim, and of the society. Therefore, fair trial includes the grant of fair and proper opportunity to the person concerned, and the same must be ensured as this is a constitutional as well as human right. Thus, under no circumstances can a prisoner's right to fair trial be jeopardized. Adducing evidence in support of the defense is a valuable right. Denial of such right would amount to denial of fair trial. Thus, it is essential that the rules of procedure that have been designed to ensure justice are properly followed, and the cost must be zealous, ensuring that there is no breach of the same. This is said in so many judgments as is before you in the screen. So read it yourself. I am going to next page of my presentation. I am discussing about one judgment, that is Jamtraj Kevalji Govani versus State of Maharashtra, AIR 1968, Supreme Court 178. In this case, what the court said, it would appear that in our criminal jurisdiction, statutory law confers a power in absolute terms to be exercised at any stage of the trial to summon a witness or examine one present in court, or to recall a witness already examined, and make this the duty and obligation of the court, provided the just decision of the case demands it. In other words, where the court exercises the power under the second part, the inquiry cannot be whether the accused has brought anything suddenly or unexpectedly, but whether the court is right in thinking that the new evidence is needed by it for the just decision of the case. If the court has acted without the requirement of just decision, the action is open to criticism. What if the court's action is supportable as being in aid of the just decision? The action cannot be regarded as exceeding the jurisdiction. Now, another judgment is Mohanlal Shyamji Soni versus Union of India, and another 1991, SCC 2001. This court again highlighted the importance of power to be exercised under section 311 CRPC as under in paragraph 10 of this judgment, in order to enable the court to find out the truth and render a just decision. The salutary provisions of section 540 of code, which was earlier, now it is 311 in the new code, are enacted whereunder any court, by exercising its discretionary authority at any stage of inquiry, trial, or other proceeding, can summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall or re-examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined who are expected to be able to throw light upon the matter in dispute. Because if judgment happens to be rendered on inchoate, inconclusive, and speculative presentation of facts, the ends of justice would be defeated. Now, coming to another judgment, that is Rajdev Sharma versus State of Bihar. It is of 1999. In this, what the court said, we may observe that the power of the court under section 311 of the Code of Criminal Procedure has not been curtailed by this court, neither in the decision of 5-judge bench in A.R. Antale case nor in Kartar Singh case. Such power has been restricted for achieving speedy trial. In other words, even if the prosecution evidence is closed in compliance with the directions contained in the main judgment, it is still open to the prosecution to invoke the powers of the court under section 311 of the code. We make it clear that if evidence of any witness appears to the court to be essential to the just decision of the case, it is the duty of the court to summon and examine or recall and re-examine any such person. In duty of Dadra and Nagar Haveli and another versus Fateh and Mohan Chauhan. It is of 2006. A conspectus of authorities referred to above would show that the principle is well settled that exercise of power under section 311 CRPC should be resorted to only with the object of finding out the truth or obtaining proper proof of such facts which leads to just and correct decision of the case. This being the primary duty of the criminal courts. Calling a witness or re-examining a witness already examined for the purpose of finding out the truth in order to enable the court to arrive at the just decision of the case cannot be dubbed as filling in a lacuna in the prosecution case, unless the facts and circumstances of the case make it apparent that exercise of power by the court would result in causing serious prejudice to the accused, resulting in miscarriage of justice. In Idhar and others versus Abida and another, AIR 2007, Supreme Court 3029. The object underlying section 311 of the code is that there may not be failure of justice on account of mistake of either party in bringing the valuable evidence on record or leaving ambiguity in the statements of witnesses examined from either side. The determinative factor is whether it is essential to the just decision of the case. The section is not limited only for the benefit of accused, and it will not be an improper exercise of power of the court to summon a witness under the section merely because the evidence supports the case for the prosecution and not that of the accused. This section is a general section which applies to both proceedings, inquiries, and trial under this code, and empowers the magistrate to issue summons to any witness at any stage of such proceeding, trial or inquiry. In section 311, the significant expression that occurs is at any stage of inquiry or trial or other proceeding under this code. It is to be borne in mind that whereas this section confers a very wide power on the court on summoning witnesses, the discretion conferred is to be exercised judiciously, as the wider the power, the greater is the necessity for application of judicial mind. Hoffman Andrews versus Inspector of Customs Amritsar 2000 SCC 430. Grant of fairest opportunity to the accused to prove his innocence was the object of every fair trial observation of this court in the judgment. Now, next judgment is P. Sanjeeva Rao versus State of AP AIR 2012 Supreme Court 2242. The scope of Section 311 Crpc, the following passage is in this regard to be read. In such circumstances, if the new counsel thought to have the material witnesses further examined, the court could adopt latitude and a liberal view in the interest of justice, particularly when the court has unbridled powers in the matter under section 311 of the code. After all, the trial is basically for the prisoners and courts should afford the opportunity to them in the fairness manner possible. We are conscious of the fact that recall of witnesses is being directed nearly 4 years after they were examined in chief about an incident that is nearly 7 years old. Delay takes a heavy toll on the human memory apart from breeding criticism about the efficacy of the judicial system to decide cases within a reasonable, foreseeable time period. To that extent, the apprehension expressed by Mr. Rawat that the prosecution may suffer prejudice on account of belated recall may not be wholly without any basis. Having said that, we are of the opinion that on a parity of reasoning and looking to the consequences of denial of opportunity to cross-examine the witnesses, we would prefer to err in favor of the appellant getting an opportunity rather than protecting the prosecution against a possible prejudice at his cost. Fairness of the trial is a virtue that is sacrosanct in our judicial system, and no price is too heavy to protect that virtue. A possible prejudice to prosecution is not even a price, even on one that would justify denial of fair opportunity to the accused to defend himself. In Natasha Singh versus CBI, Criminal Appeal number 709 of 2013, where one of us was party, in Natasha Singh, repeating due to some technical problems, in Natasha Singh versus CBI, Criminal Appeal number 709 of 2013, where one of us was party, various other decisions of this court were referred to, and position has been stated under paragraph 14, which I am reading just now. The scope and object of the provision is to enable the court to determine the truth and to render a just decision after discovering all relevant facts and obtaining proper proof of such facts to arrive at just decision of the case. Power must be exercised judiciously, and not capriciously or arbitrarily, as any improper exercise of such power may lead to undesirable results. An application under Section 311 CRPC must not be allowed only to fill up the lacuna in the case of prosecution or of the defense, or to the disadvantage of the accused, or to cause serious prejudice to the defense of the accused, or to give an unfair advantage to the opposite party. The additional evidence must not be received at the disguise for retrial or to change the nature of the case against either of the party. Such a power must be exercised proper, provided that the evidence that is likely to be tendered by a witness is germane to the issue involved. An opportunity of rebuttal, however, must be given to the other party. The power conferred under Section 311 CRPC must therefore be invoked by the court only in order to meet the ends of justice for strong and valid reasons, and the same must be exercised with great caution and circumspection. The very use of words such as any court, at any stage, or in any inquiry, trial, or other proceeding, any person and any such person clearly spells out that the provisions of the section have been expressed in the widest possible terms and do not limit the discretion of the court in any way. There is no escape if the fresh evidence is to be obtained is essential to the just decision of the case. The determinative factor should therefore be whether the summoning, recalling of the said witness is in fact essential to the just decision of the case. While dealing with an application under Section 311 CRPC, read with Section 138 of Evidence Act, we feel the following principles will have to be borne in mind by the courts. These under below principles are for the court before allowing the application under Section 311. First one is whether the court is right in thinking that the new evidence is needed by it, whether the evidence sought to be led in under Section 311 is noted by the court for a just decision of the case. The exercise of the widest discretionary power under Section 311 CRPC should ensure that the judgment should not be rendered on inchoate, inconclusive, speculative presentation of facts, as thereby the ends of justice would be defeated. If evidence of any witness appears to the court to be essential to the just decision of the case, it is the power of the court to summon and examine or recall or re-examine any such person. The exercise of power under Section 311 CRPC should be resorted to only with the object of finding out the truth or obtaining proper proof for such facts which will lead to just and correct decision of the case. The exercise of the said power cannot be viewed as filling in a lacuna in a prosecution case unless the facts and circumstances of the case make it apparent that exercise of power by the court would result in causing serious prejudice to the accused, resulting in miscarriage of justice. The wide discretionary power should be exercised judiciously and not arbitrarily. The court must satisfy itself that it was in every respect essential to examine such a witness or to recall him for further examination in order to arrive at just decision of the case. The object of Section 311 CRPC simultaneously imposes a duty on the court to determine the truth and to render a just decision. The court arrives at the conclusion that additional evidence is necessary not because it would be impossible to pronounce the judgment without it, but because there would be a failure of justice without such evidence being considered. Exigency of situation, fair play, and good sense should be the safeguard. While exercising the discretion, the court should bear in mind that no party in a trial can be foreclosed from correcting errors, and that if proper evidence was not adduced or a relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such mistakes to be rectified. The court should be conscious of the position that, after all, the trial is basically for the prisoners, and court should afford an opportunity to them in the fairest manner possible. In that party of reasoning, it would be safe to err in favor of the accused getting an opportunity rather than protecting the prosecution against possible prejudice at the cost of accused. The court shall bear in mind that improper or capricious exercise of such a discretionary power may lead to undesirable results. The additional evidence must not be received as a disguise or to change the nature of the case against any of the party. The power must be exercised keeping in mind that the evidence that is likely to be tendered would be germane to the issue involved and also ensure that an opportunity of a rebuttal is given to the other party. The power under Section 311 Crpc must therefore be invoked by the court only in order to meet the ends of justice for strong and valid reasons, and the same must be exercised with care, caution, and circumspection. The court should bear in mind that fair trial entails the interest of the accused, the victim, and society, and therefore the grant of fair and proper opportunities to the persons concerned must be ensured, being a constitutional goal as well as human right. Now, there is one case recently decided, that is Rudra Narayan Sahu versus State of Odisha. Case number is CRLMC number 947 of 2023 and judgment dated March 15, 2023, just a week before. In this case, the Odisha High Court allowed a petition filed under Section 311 of the CRPC after a delay of 26 years for recalling a witness who was cross-examined and discharged in 1997. While stressing on the right of accused to fair trial, the single-judge bench of Justice Shashikanta Mishra observed, "This is a classic case where the question of belated justice is pitted against the right of the accused to a fair trial. Having regard to the fundamental principles enshrined in the Constitution of India, this court would rather lean in favor of the latter, that is accused, than the former, prosecution, so that the end result of rendering of justice to the party is actually realized." Clapping for this honorable justice. Now, I would like to thank you all who are watching this video, but I will also request to please share with others so that they may get benefit from this, my presentation, and I will request you to subscribe and like and forward. I am Ashok Arora from Chandigarh, practicing as advocate in District Court, Chandigarh, and my cell phone number is 9888 Once again, thank you for watching. God bless.